Did you know that it is very much possible for you to make an oral application for bail at the High Court? Let me give you a little background story of what happened to me sometimes in June 2024. So I was at home preparing for work and I got a call that one of my clients was about to be arraigned before a high court in Abuja. And I had to quickly get dressed and rush to the court. So which means I was unable to file a bail application, a motion for bail for my clients. If you want to know how to move a motion for bail, I have about 2 contents on bail on my YouTube channel. So I will try and drop the link to those videos. One on how to move oral application for bail at the magistrate court, because that is allowed for you to make oral application for bail at the magistrate court. And I also have another video on how to move a bail application at the High Court. Okay, so as I was saying earlier, I had to rush to the court because it was just like an impromptu call. I was not planning to even appear before any court on that day. I was just at home getting dressed, and that was about 9 a.m. So I did not have that opportunity to file a process. So during the course of my research, I got to realize that there is no law that mandates that as a defense counsel, you need to file a motion for bail. This is what I'm saying. No law mandates it. That doesn't mean you cannot file an application for bail, but no law mandates it. Like there is no word shall, like a defense counsel or a defendant shall, by way of a written application, apply for his or her bail. There is nothing like that. Okay, but there is this common practice that when a defendant has been arraigned before the court, we are just after is after the arraignment. We are after the fact that before the High Court, we are after filing an application and moving such application. And oftentimes you even see the defense counsel to be the one to apply to the court, like, my lord, I need a short adjournment for me to file my bail application. This is it. You can make an oral application for bail at the High Court, and I'm going to cite 2 authorities for that. Okay, for the part of the country where Administration of Criminal Justice Act of 2015 operates, there is this section 32 subsection 3 of that act that stipulates that application for bail, I'm paraphrasing now, may be orally or in writing. The word may makes it flexible, makes it more meaningful, that as a defense counsel you can apply to the court to move an oral application for bail. And I'll give you one gimmick for you to have a successful application, for the court to allow you to do so. Try and talk to the prosecution, particularly when that offense, when the charge is not a capital offense. We all know that capital offense are the type of offense that the law actually frown at you giving a bail, like granting bail to the accused or to the defendant. But when the offense is nothing like a capital offense, talk to the prosecution before you make your application, before the matter is even being called, that okay, this is what you want to do. If the prosecution is like, no, I need to get an application served on me, make him to understand that this is what the provision of the law is. So for other jurisdictions that they don't operate under the Administration of Criminal Justice Act, it is possible that you have a law, the state where you practice, that have a law that stipulates something like this, or you can use this judicial authority, the case of FRN against MKO Abiola. So in that case, the fact of the case is just that he made an application for bail, which was refused, application for bail orally, which were refused by the lower court. And at the Court of Appeal, at the Superior Court, I'm not so sure that it was the Court of Appeal or the Supreme Court, he won. The appeal succeed that no law mandates that the application must be by in writing. Do you understand? So you see oftentimes that the prosecution will be the one to object, like, oh no, I need a written application. That is subject to the court's discretion. It is only the court, the judge, that would say, okay, I need you to put whatsoever you are praying the court for, I need you to put it in black and white. But it shouldn't be for the prosecution to say, I need it in, according to my own understanding of this principle of law, particularly from this FRN against MKO Abiola, you can make your application orally. So that is subject to the approval of the court, not to the approval of the prosecution. I'm only saying so that you don't have this tough arguments in court and things like that. That's why I said earlier that it's advisable that you meet with the prosecution on the other side and make him or her to understand that you're about to do this. Okay, you know, there's this presumption of innocence according to the Constitution. So if you are presuming someone to be innocent until the contrary is being proven, and at the point of arraignment you are saying this person does not have the right to be granted bail, or even if the court is not saying that, for some reasons courts can deny bail application, which is very, very much valid. But you know, oftentimes in a situation like this, if the court is to say, according to the authority of FRN against MK Abiola, if the court is to say because an application is yet to be brought, can I use the word formally, it's going to be prepared in a book, in a motion, and to be filed and to be served on the other party, that's because of that you would make that person to be in the prison pending the next adjourned date. According to that authority I've cited earlier, it's 1995 NWLR. I will try and drop the citation in the description box. So the courts in that during that appeal see that since this person is still presumed innocent, the fact that a written document is yet to be before the court should not be enough reason to not to hear the defense counsel about the bail application. This is why, as a lawyer, as a new wig, as an intending lawyer, it is very important for you to always do research. I do tell people that research, for me, research is one thing that is very paramount. If you're applying against SAN, Attorney General, I do tell people you don't need to, just have your confidence, and your confidence will come by you researching. Once you do your research, if you inform the court, when you inform the court that you want to move a bail application orally, like you want to apply orally, probably the court is not even aware of this provision of the law, or the other party is not aware, but because you have your notes, you have your research with you, you can easily make it known to the court. You can't just go to court and say you want to make an application for bail orally, and the court will be like, why, how, what do you mean? You should be able to guide the court properly by you citing, if possible, get the law report with you. You can oblige the court from the bar, like the court will just go through it, and that way the court will have more security in what you're telling the court, because since you're not just reading it from your head, you're not saying it is a trite law or something like that. You know, you can make your dictate the citation, or if you have the law report, or even if it's on Law Pavilion, just say something out there that will make the court to understand the basis. Like you're not just coming from your own understanding. I mean, like you have an authority for what you're saying. So basically, that is all I have for you in this video. I hope you enjoyed this video. Please do not forget, always subscribe, like, and share this video. And another thing you can do to support me on this YouTube channel journey, it has been a long time coming. Please always try to at least watch 1 or 2 ads on my videos. Watch it to the end. That's another way you can support me. Thank you so much, and I will see you in another video.